Hi, welcome back to the podcast, HOA Hell. I'm your host, Michael Kushner, and with me today is Senior Associate from MBK Chapman, Sam Kill. Sam,
Hello.
Good morning.
Morning, Mike. How are you?
I'm fine, thanks. Sam, this morning, we're going to talk about, I think, a topic that's going to be a very helpful guide for our listeners. You and I both know that the vast majority of homeowners that live in HOAs have never read from cover to cover their CC&Rs.
Oh, yeah, no, it can be very intimidating to them, and they've not, yeah.
And there's very good reasons why you have it for the most part, okay? Number one, it's intimidating. It's a long document, often over 100 pages. Two, it's written in a lot of jargon and a lot of legalese and antiquated language, which is unfortunate because it's just a reflection of bad lawyer writing and bad lawyering. And it's boring for the most part. At least when you're reading rules, those apply to your everyday life. Like when you're reading about, the rules regarding parking or the trash cans or pets, you can apply that to your real life. But for the most part, except for certain aspects of the CC&Rs, a lot of it is very dry and boring when they talk about things like annexation or eminent domain or taking. I mean, it's like, who cares, right? And so there's a very good reason people don't read them.
Right.
So today, we are going to solve the problem. Because we have said in many of our podcasts, read your governing documents. Read your governing documents. You got to know what they say. But as I started thinking about that, it really wasn't ever read page to, cover to cover, page to page, your governing documents. There are parts you can skip. So today, what I'm going to do is I'm going to break down all the parts of your CC&Rs that you can ignore completely unless something in the future arises, and that's probably not going to happen, and the parts that you need to pay attention to and read. And even though I'm not going to name all the parts you can ignore, the kind of a general rule for you is if I didn't include it on one of the sections you must read, you can probably ignore it. And so, although I am going to point out specifics, or we are going to point out specifics as to what can be ignored, even if I don't name it, you can probably ignore it if it's not one of the ones I told you, you must read this. So I'm going to make it very simple for everybody. That's what we're going to do. Now, let's start with table of contents. If your HOA was formed anytime from the mid-90s or anytime in the 2000s, it's very likely that your CC&Rs have a table of contents. Or if your HOA amended their CC&Rs from, from the mid-90s all the way through today, it's hopeful that they upgraded them by including a table of contents. But table of contents is really helpful for us as lawyers and for you because it really just shows you where everything is. Unfortunately, the older sets of CC&Rs, they didn't do that. It started with recitals and went right into article or section 1 and bam. And if you wanted to find something, you either had to read or do an optical character recognition or OCR of the document and do a word search.
Yep.
It's just dumb. But if you're one of the many that lives in an HOA that has CC&Rs with table of contents, you're ahead of the game. That's great. So here's the thing. If, as you sit here today listening to this podcast, if you go pull up your CC&Rs and they have a table of contents, great. Just keep listening. If they don't, my recommendation is that I'm assuming you're looking at a PDF. My recommendation is to basically OCR or optical character recognition your document so that it becomes searchable. Okay? So you're going to have to do what you're going to do. You can Google how to do that. It's very simple. But you want to make sure you can search because otherwise it's going to be a slog. Okay? Now, assuming table of contents, it'll be so much easier when I talk about things like maintenance obligations or use restrictions or architectural and design control. If you can just see those terms in your table of contents or terms that are similar to those in your table of contents, you'll kind of know exactly where to read. So that's kind of a good start, okay? Now, let's talk about the first big topic today. And Sam, you're going to step in and help me here, okay? Let's talk about all the parts of your CC&Rs that you can 100% ignore, okay? And again, even if I don't mention all of them in this list we're about to talk about, if I don't tell you to actually pay attention to them, you can probably ignore it, okay? Now, of course, one or a few of these might become relevant in the future. For example, if your HOA suffers from a massive fire and burns down completely in the future, there are going to be some provisions you're going to want to read that for now I might tell you to ignore. Yeah, if it becomes relevant, you read it, okay? So I say this to imply that there are large sections of your CC&Rs that are filled with technical clauses that don't and won't affect your daily life for the most part, okay? So I'm not telling you throw these away, cross them out. Don't do that. No. Just don't read them for now. Just skip over it and only go to the parts I tell you to read. It'll take this big task and make it much more simple, and then you're more likely to actually read the parts that you should read so you know what your rights are, because it's the only way to protect them. Okay? Now, here are some of the most common examples of the provisions that you can safely skip. Okay? Let's start with a big one. Conflicts between documents, or something to that effect. California Civil Code, Section 4205, already sets the hierarchy. The law is first, then the CCNRs, then the bylaws, and then the rules or architectural guidelines. The law tells you what the order is. So there's no need for you to even bother reading the conflicts between documents sections. You can ignore it.
Right.
Sam, give me another one.
Mike, another one is developer declarant provisions. Basically, if your HOA is no longer under the developer control, these are usually expired and irrelevant.
So when the developer, or in many cases it's called the declarant in your set of CC&Rs, has started the community or built the association, not all the houses have been sold yet, or it might not even be fully constructed. If it's released in phases, only certain parts might be open. And so the declarant or the developer stays on and controls the board until a certain predetermined percentage of homes have been sold, at which point that person gets off and the board is completely elected by the members through the normal course. So any parts that talk about the developer or the declarant and the developer or declarant's rights or processes are probably not going to be relevant for your HOA unless you're still in an HOA where the developer or declarant is still in charge. And that's very few.
In most cases, it's many, many decades ago.
Right.
When that happens,
so we're going to, for the most part, you can ignore. Okay? The next one would be damage or destruction. These sections are relevant if there's a major loss. A massive earthquake literally topples your condo buildings. Or there's a huge fire like what happened in the Palisades, and the entire community is just gone, reduced to ash. Then the damage or destruction provisions are going to be very important. Okay? Now, I don't want you to confuse this with damage that occurs to the common area or what happens if a member or a guest causes damage to the common area. It's not what we're talking about. We're talking about the part that's damage or destruction of the community or large portions of what makes your HOA your HOA. And those only occur in the case of massive disasters, okay, or big problems. So you can, for now, unless you're one of the ones that just lost everything, you can ignore that, okay? Sam, can you think of another one?
Sure, Mike. I think you briefly alluded to this earlier, but it's basically eminent domain or condemnation.
Right.
So this is when the government forcibly takes, this could be federal, state usually, or county authorities, take some portion of private property, in this case your HOA's property, for a government interest, such as building a highway, possibly expansion of roads, streets. But because it's so rare in the context of residential HOAs, it's really not worth worrying about unless it happens to you.
Exactly. So you can probably ignore the eminent domain and condemnation provision. Another one is provisions related to the rights of the mortgagee or the lender. A mortgagee is basically, it's the bank that's holding your mortgage, okay? Protect lenders, not homeowners, okay? And they relate to lender rights, such as subordination rights or the lender's rights, what if they foreclose on a given property, what rights are triggered. Or even their right, in many CC&Rs, their right to attend board meetings, even though they're not members. Those don't apply to you, so you can ignore them for the most part. Another one is something annexation. Tell me about annexation, Sam.
Sure. Well, this is typically only relevant if your HOA is still in a development phase or adding new phases perhaps to the community. It usually describes the voting threshold necessary for the HOA to annex or acquire land that doesn't yet own.
Exactly.
It's an expansion, really.
Exactly.
Yeah.
And for established HOAs, it's not really going to be an issue.
No.
Okay? Another one is power of attorney to the HOA. That's just kind of standard legal language that has no effect on your daily rights. Another one is tax lien priority clauses. Anything that relates to tax liens, those are governed by state law, folks. So, and the CC&Rs and many sets of CC&Rs have provisions regarding that. They just mirror what the statute says. To the extent they don't because they're older, they're superseded by the statute, so it doesn't even matter what's in them. So either way, it doesn't matter. You can ignore it, okay? And then the last part is fidelity bond coverage. And the reason you can ignore that is the law, that's one of the few policies that the law requires. This fidelity bond, and we've talked about it in a prior episode when we were talking about the types of directors or people that can be barred from serving on the board.
Right.
And one of the acknowledged and permitted exclusionary rules to say, if this is the fact you can't be on the board, was if some conviction on the part of somebody interested in serving on the board would prevent the HOA from carrying a fidelity bond, which it's required to do, then they can be excluded. Well, I don't think you need to know that.
Right.
Now, let's now transition to the more important part of this podcast, which are, these are the parts of your CC&Rs that you should 100% read and understand so that you can protect and enforce your own rights and you know where you stand in terms of the law and your HOA. Okay? So we're going to turn to those provisions of the CC&Rs that I want you to read, that I want you to understand and know. Okay? The first and foremost, most important, is maintenance and repair obligations. Okay? Find the section in your CC&Rs that spells out who is responsible for maintaining, repairing, and replacing each part of the property. And I'm talking about the common area properties, not your own personal property. Okay? This often covers roofs, if you're in a condo, let's say. Roofs, balconies, exterior walls, plumbing systems, landscaping, for example. Those obligations determine who pays when something breaks or wears out or needs to be replaced. Now, some CC&Rs, probably the newer ones or more recent ones, but not always, have attached as very helpful exhibits. So maybe not part of the main body, maybe yes, but mostly not. It's an exhibit that's attached to some top point. And they have a table, that has 2 columns, or 3 columns, I guess. One will say owner or member, and the other will say association or HOA, and then it'll be a description of a component. And it'll have an X in one or both those boxes, and it tells you who's responsible, okay? Who's responsible for these pipes or the roof or for this or for that, and there'll be an X. This is the association. This is the association. That's the owner, association. If yours has that, fantastic. It just makes life easier, okay? If yours doesn't, that's okay. It'll still be spelled out in prose. Sam, another one of them is the definitions of common areas and exclusive use common area. Right. Talk to me about that, please.
Well, that's an important distinction, too. So definitely worth looking into. And basically, this is understand where the areas are shared by all owners and which are for your exclusive use, but still owned by the association. So examples include patios, balconies, storage units, and assigned parking spaces.
Those are the most common examples.
Exactly. Yeah. And the definitions here will affect your maintenance responsibilities and your right to make changes.
Right.
As you discussed.
Right.
Yeah.
Okay. So that's pretty self-explanatory. You want to know what is common area, what's the definition first, and what is it, and what is exclusive use common area, because they often have different maintenance responsibilities, so you want to be careful about looking at that. Our next one that you must read, you must understand, is something close to use restrictions.
Huge.
And it could be restrictions on use, it could be use restrictions, and there can be even other words that are synonyms, but it's the same thing. And basically, this is where you'll find the rules that affect your daily life the most. These often include issues or things like the pet restrictions on breed, size, and number of pets, or vehicle use, including prohibited vehicles like RVs, off-road, non-street legal motorcycles or boats, that sort of thing, or garages and parking, where you're allowed to park, where you're not allowed to park, what your rules are in terms of parking elsewhere when you have a garage or if you don't have a garage. Those kinds of rules, okay? Rentals, short-term rentals, long-term rentals, and what the limitations, if any, for your HOA are regarding that. Smoking, whether it's marijuana or cigarettes or pipes, or running a business. Often CC&Rs will have, provisions about that sort of thing. You're only supposed to use this, for residential uses and no business, something to that effect. Prohibited activities, okay? Some nuisances, such as noise or noxious fumes, and other things like that. There might even be separate sections for nuisance. Anything that relates to the behavior or what you can or can't do with your property or with the common area. Those are the use restrictions we're talking about, okay? Sam, another one is architectural control and approval process. That's
Right.
one of the majors. Tell me about
Huge,
that.
massive. I mean, this comes up all the time. So here, read how you must submit your request for changes to your unit or lot.
So what do you mean by that? Read, you must submit. What does that mean?
I mean how that application process works, right? So basically the bolts, the nuts and bolts of how you procedurally are to submit those applications, and to ensure that those applications are complete, comport with the various requirements as articulated under your CCNRs. And basically the timelines for the approval, that's critical. We've discussed this in prior episodes. If you have, let's say, a 30 or 45-day timeline for them to respond and approve these, and if they fail to do so, they're automatically deemed approved. That's critical.
If your documents actually have that provision.
Exactly.
Right.
So here...
And by the way, some of those, the CC&Rs will cover it, but it'll also give the authority for the HOA to pass rules. And there might be a separate document that goes into more detail called architectural guidelines or architectural rules. It could be phrased a million different ways. It usually has the word architectural in it. So you would read that in conjunction with, of course, your CC&Rs. The next one is, I think this is a biggie, rulemaking authority. Okay? I've mentioned in prior podcasts that unless an HOA's CC&Rs, articles of incorporation, or bylaws, one of those three documents, specifically empower and authorize the HOA to make rules, then the HOA can't do it. Now, I also said that in the vast majority of HOAs in California, and I can't think of a particular HOA off the top of my head that doesn't have it, that provision exists, mostly in the CC&Rs, but it could be in the other two documents as well, but it exists. So for our purposes, HOAs have that power. But you want to look and see if it does. If yours doesn't, and they have a set of rules or architectural guidelines that aren't in the CC&Rs, they are not going to be enforceable. So that's why that's important, okay? You do not typically have to read the entire provision. You just have to read the part that where your HOA is authorized or empowered to promulgate rules, and if they are, then rules are going to be enforceable if they meet other guidelines that we discuss in a separate show, of course, okay? For the most part, CC&Rs just mirror the law anyway, but sometimes they exceed the law, and they provide homeowners with more protection. So an example of that is, let's say the Davis-Sterling Act allows you 30 days to do something, or says that the HOA must give you 30 days. Your HOA can give you 40 if they want, okay? They just can't give you less than a statutory minimum, but they can give you more. So some sets of rules do that. That's why you want to read these. You want to know, A, whether or not your HOA has rulemaking authority, and B, whether or not the rulemaking authority is running afoul or not running afoul of the law, okay? Another one is, and this is one that's been in the news very recently, is enforcement and fines. It might not always be called that. It might be called discipline. It might be called violation, rule violations. But anything that relates to the enforcement of rules or the punishment or discipline for violating the rules, often by fines or suspension of privileges, that's what we're talking about here. This section, therefore, as you might have already surmised, describes the process for imposing fines or other penalties, including the notice of hearing requirements and all the stuff that was recently covered or changed under AB 130. It explains the types of violations the board can penalize, because you can't get punished, for example, and I've talked about this in other episodes, you can't get punished for something that doesn't violate your governing documents. Just because somebody on the board or some members of the board think, we don't like that thing. If it's not barred, they can't discipline you, period. End of story. If there's no rule or provision of your CC&Rs or rules that say you can't do X, then if you do X, they cannot discipline you. If they don't like that, they can change a rule. They can add a rule properly by following the steps. But until they do that, they can't discipline you. So you got to kind of know what's there so you know what they can and can't do. That makes sense. We mentioned earlier, Sam, I mentioned, under the use restrictions, we talked about there might be discussion of things that constitute a nuisance. But a lot of HOAs have a separate provision for nuisance provisions.
Yeah,
Tell me about that.
Yeah, that's one of the major ones that comes up all the time for most HOAs. And these basically cover activities like noises, odors, or other conditions that interfere with other owners' use and enjoyment of their property. So these could be, patently offensive conduct or things of that nature.
Illegal conduct.
And oftentimes these provisions are used to resolve neighbor disputes.
Right. So they're neighbor-to-neighbor disputes for the most part, and they could be noxious fumes. Your neighbor is constantly smoking when there's no smoking policy, or your neighbor's cooking meth. Hopefully not, but there's strong odors associated with that. Plus, explosion risk, which is another nuisance, is a nuisance because there's a strong chance of death and destruction. So anything that affects negatively your use, your quiet enjoyment or use of your property under the law constitutes a nuisance, and most sets of CC&Rs have a specific provision that bars members from engaging in nuisance activities. So, although mostly in the context of neighbor-to-neighbor, member-to-member disputes, because HOAs have a duty to enforce, it involves the HOA as well. So you want to look at the nuisance provision just to see what it says, okay? Another one is signs and displays. There is almost always a provision in your CC&Rs, and sometimes, and often in the rules as well, but there's often a provision in the CC&Rs that talks about your right to signage or displays, maybe for, commercial versus personal, or even flags. Well, what you need to know is what it says, because I've told you in some prior podcasts that the law protects your right when it comes to flags or non-commercial signs of a certain size. You have an absolute right to have those up, regardless of what your governing documents say. But your governing documents can control other kinds of signage. So you have to know what you're allowed to do and what you're not, including, when can I put up a for sale sign or open house sign, and where does it have to go? And how big can it be? And all those things, that is very, very likely going to be covered in your CC&R. So you need to know that. Another one is party walls and shared structures. If there's a provision in your CC&Rs regarding party walls and shared structures, we're talking about the walls between in your backyard, between neighbor homes. We've talked about this in one of our 6-part series on neighbor disputes when we talked about line walls and non-line walls. And a party wall is typically a wall where one homeowner is responsible for their side of the wall and the other homeowner is responsible for their side of the wall, and they're both responsible for the exact center, and if it has to be repaired or replaced, they kind of have to split the costs. But you want to see what it says about that. So anything related to shared structures, that it's not, a lot of HOAs, let's say they'll have, even though homeowners own their driveways, let's say the same driveway services 2 homes, you guys actually probably have shared responsibility for that, for the front portion of the driveway, and then maybe it splits into your separate unit, right? In that kind of case, you're going to want to know what your CC&Rs are saying about that. So you're going to want to read that. Sam, another one is easements.
Right.
Okay? With easements, remember, folks, and I've said this in prior podcasts, we're talking about your right to access somebody else's land. It's not land that you own. It's somebody else's land, okay? And those legal rights are for use of portions of someone else's property for a specific purpose. In HOAs, common examples include utility easements, access easements for maintenance or shared driveways. If your HOA has those green boxes in front of or in between every 4th home, let's say, those might be for cable and satellite service. You're gonna have the different homes that are serviced by that box are going to have easement rights to that. They're not going to own the land. It's owned by probably the HOA, but they're going to have rights to access it or have their vendors access it. That's what we're talking about here. We're not talking about a private easement that you might have over a neighbor's land, and we're not talking about a private easement that you might have over another member's land. We're talking about an easement that you have over most likely HOA property. Another example sometimes that you see, and this would come up more in the context of a multifamily, condo situation, is one, let's say in between floors, there might be dead space, and both homeowners might have a right to, run cable or wire up in that dead space, right? And neither of them might own that. Or there might actually be, you own 6 inches above and he owns 6 inches below, and that's where they meet, but you each have an easement into that airspace to run wiring. So that's what we're talking about there, but that's not a private easement, that's just an easement, okay? It's not a privately negotiated easement. So that's what we're talking about. And now we get to the insurance requirements. Well, let's talk about the insurance requirements for owners. These are absolutely important and critical for you to know, because this tells you, hey, members, you have to have this type of insurance. Again, often in condo situations, you're required to have certain types of insurance as a member. If your HOA's CC&Rs say you must maintain X kind of insurance, you better have X kind of insurance. Sam, another one is voting rights and amendment procedures. Tell me about that.
Yeah, I mean, so these explain votes, how votes are counted, how special meetings can be called, and a percentage of owners required to approve changes to the CCNRs.
Exactly.
Yeah.
Exactly. So very simple, very straightforward. And another one is allocation of assessments. These provisions, to the extent they exist in your CC&Rs, just detail how the regular assessments are calculated, whether they're calculated equally based on every home pays the same amount, or as a percentage of square footage, or the type of house. All of our condos pay this, and all of our single-family homes of this square footage pay this, or it's a percentage of square footage. It can be a variety of different ways, but it does spell out how they're calculated. You have to know about that, because if there's ever any assessment, whether it's a special assessment or just the calculation of your general assessment, you want to make sure that somebody did the calculation correctly, so that you're paying what you're supposed to pay, not more. Okay? And so those are pretty much the provisions that I want you to pay attention to. Those are the provisions you should know and be able to access quickly and know where they are and have read them. Okay? Because in my opinion, the provisions we just talked about are not optional. You have to know them. They're the backbone of your rights and obligations, not only from you to other members of your association and to your HOA, but vice versa. It's the backbone of the obligations owed to you by your HOA to you and your other members to you. For example, the nuisance stuff, okay? So if you read nothing else in your CC&Rs, make sure you read and understand every item that I just discussed in the last several minutes that were on that list. Everything else, I leave it to you. But those things you must read. And you'll find we've drastically shortened your homework assignment, because now when I say read your governing documents, you don't have to read the whole set of CC&Rs, just the stuff we talked about. Now, quick note on the stuff about what you should and shouldn't ignore, okay? I spent a good deal of time, last 25 minutes or so, discussing various provisions of your CC&Rs that you can ignore and the various ones you can't ignore, okay? The truth is, the list of provisions that you can't ignore is probably significantly longer than the list that I gave of you can ignore. So I want to reiterate something I said earlier. If it's not on the list of must understand, must read, then I'll leave it to you to judge whether you should read it, but you can probably skip it. Unless, of course, the situation arises that makes it relevant. I think we can wrap up now. Folks, I think if you follow the two lists, you will have gone a long way toward incentivizing yourself to take another look at your CC&Rs, and now that you have a smaller assignment, maybe it's not going to be so intimidating. Taking a look at, again, just go look at the list of the, you must read these and just read those. And don't read anything else. Skip all the other stuff. You don't need to know it, okay? Your CC&Rs are not just a stack of documents that people like giving homeowners and HOAs, and they want to kill as many trees as possible. That's not what they're for. They actually serve a very, very important purpose. And the more knowledge you have about what your obligations are, because remember, guys, CC&Rs, other than what the law says, the CC&Rs are the top of the chain. They're the 10 Commandments. You should know what those say, okay? Everything stems from that. So open up your CC&Rs, maybe for the first time in a long time, with a plan in mind. And that plan should be, I'm going to look through this document for the provisions that Michael Kushner and Sam Kill discussed in this podcast, and I'm going to review those, and I'm going to ignore everything else. That's your plan. And if you do that, you're going to be fine, okay? Now, if you need help, or you're ever in a situation where you're not sure what your rights and obligations are, notwithstanding the fact that you read the provisions that I told you should absolutely read, then help is just a phone call or an email away. Contact us at MBK Chapman, and we'll set your HOA straight. I'm Michael Kushner. This has been another episode of HOA Hell. If you like this episode, please hit the like button and be sure to subscribe to our channel if you haven't already done so. If you want to leave a comment or ask a question, we love to read comments and answer questions, so please do so. And until next time, have a wonderful day.